Welcome back to La Belle Vie. So in anticipation of all of the pretrial motions we'll hear this week in the Dan Markel case, I wanted to talk a little more about Donna and Harvey Adelson and the state subpoenas that were served on them. Now, these subpoenas have spurred a lot of motions, so I thought we would talk a little bit more about it. Now, it may seem a bit more complicated because of the amount of paper that has gone in connection with these two subpoenas, but it's actually, I don't think, as complicated as it may appear. Now, I'm going to summarize quickly what happened in chronological order because I think sometimes that makes it easier to understand. So the state issued two subpoenas in late August and September, one trial subpoena and a witness subpoena. Now, the Adelsons' attorney informed the state that she does not believe that the interview or the witness subpoena confers the same use and derivative use immunity that a trial subpoena confers. And so it was for this reason that on October 2nd, she confirmed that Donna and Harvey Adelson would not be participating in the then scheduled October 3 interview. It was to take place at the FBI office down in South Florida in Miramar, Florida. Now, taking a step back, I thought it would make sense to explain the interrelationship of the Fifth Amendment and how that works with the state's use and derivative use immunity that's related to the subpoenas. Now, probably everyone's familiar with one of the rights that the Fifth Amendment provides to us, and that's the protection against self-incrimination. Now, when the state issues a subpoena, that provides derivative and use immunity. And what that means is that the state cannot use anything you say in connection with responding to that subpoena. So whether it's an interview subpoena or it's a trial subpoena, whatever that is, whether it's the interview or the trial testimony, the state cannot use whatever you say in that against you. Now, that doesn't mean they can't ultimately charge you with any crime. It's just that they can't use the statements that you made in connection with that proceeding, whether it's trial testimony or an interview, they can't use that against you. Now, of course, if you lie, that's a separate matter that would be subject to potential perjury. Okay, but generally speaking, if the state confers a subpoena, you aren't entitled to, just refuse to testify on Fifth Amendment grounds, because in those circumstances, because the state is giving you immunity and they will not be able to prosecute you, there's no need for a Fifth Amendment right. There's no need for you to claim the protection against self-incrimination because the state has provided you immunity. Now, Donna and Harvey's counsels indicate they don't agree with that, as I just mentioned. So, as I also mentioned in the state and the defense witness list video that I did not think that Donna and Harvey would participate in those witness lists unless they were going to have that state immunity. Now, of course, at the time those witness lists were filed, we didn't know anything that was going on with these subpoenas. We didn't know that the state had reached out in August and September with respect to Donna and Harvey. So when we found that out, I wasn't surprised because, like I said, I didn't see them testifying or interviewing unless there was immunity conferred by a state subpoena. And again, remember, if the defense issues the subpoena, there is no such immunity. So because the Adelsons made clear in that email that through their counsel that they would be pleading the Fifth, this next day on October 3rd, the state filed this. So here we go. Here's the petition for order to show cause. And essentially the argument is that the Adelsons were served with a state subpoena. It confers derivative and use immunity. And therefore, the Adelsons have no constitutional right to refuse to comply with the subpoena. And so therefore, the state's petitioned the court issue an order to show cause to the Adelsons as to why they shouldn't be held in contempt of court for failing to comply with the state subpoena. On Wednesday, October 4th, the court agreed and issued the order to show cause, requiring that either the Adelsons or their counsel appear at the October 9th hearing and show cause as to why they should not be held in contempt of court for failing to abide by the state subpoena. Now, again, this was supposed to happen tomorrow on October 9th with all the other pretrial motions. However, on the next day, Thursday, October 5th, the Adelson's attorney filed a motion to reschedule the rule to show cause hearing because she was going to be traveling for business and she would not be able to attend the hearing on behalf of the Adelsons. And so she basically suggested that the hearing take place this Thursday on October 12th. She also mentioned that in the event that the court does order the Adelsons to participate in the interview, that the parties had tentatively scheduled that interview to take place on October 17th. And then on Friday, October 6th, the court granted the Adelsons' attorney's motion to reschedule. And so therefore, the motion on the rule to show cause will now be heard Thursday. Now, in the meantime, not to be left out, I guess, Charlie's lawyers filed their own motion with respect to this whole Donna and Harvey subpoena. So here we go. The defense filed their motion to enforce the court's discovery deadline. Now, what's interesting that this was also filed on Thursday, October 5th. And in fact, it was filed not quite 2 hours after the Adelsons filed their motion to reschedule. The Adelsons filed their motion to reschedule at 2:43 p.m., and Charlie's lawyers filed this motion at 4:27 p.m. I'd say they clearly don't want the state interviewing Harvey and Donna. First of all, the defense admits they knew about these subpoenas. They knew about it because, one, the state actually had to contact Rashbaum to figure out who was the lawyer for Donna and Harvey. Confirm the name of their counsel. That's because, if you recall, it was reported that Rashbaum was actually the lawyer for Donna and Harvey back in earlier days. And then, of course, he wound up now representing Charlie. So who's Donna and Harvey's lawyer? So the state reaches out to him to get the lawyer, which they gave the name. And then they admit here that they found out more. I mean, they pose it as we heard nothing more on the subject, but, then they do find out here again on September 11th about the interview date. And it looks like it was going to potentially take place on a Jewish holiday. And so the state wound up proposing October 3rd. And the defense counsel says, well, we can be available then. So they clearly knew the state was looking to interview the Adelsons. Now, because the discovery deadline has passed, even though they had knowledge of the state wanting to interview the Adelsons, again, they're trying to argue that this should preclude them from being able to interview them, and also there are no exceptional circumstances to allow them to go beyond the September 22nd date. And basically what they're saying here is that in connection with this, no exceptional reason, what do you think about all this stuff? More significantly, the state's 11th hour request comes years after the state placed pen registers on Adelson's cell phones, issued third-party subpoenas to obtain their call detail reports, bank records and credit card statements, et cetera, et cetera, et cetera. It comes years after the state released probable cause affidavits accusing the Adelsons of playing a role in Professor Markel's murder and identified them in court filings as Category 8 witnesses and unindicted co-conspirators. It comes years after Catherine McBanoa filed an amended witness list naming the Adelsons as potential defense witnesses at her retrial. Okay, well, that has nothing to do with the state. And it comes 16 months after the state arrested the Adelson's son. In all that time, the state made no effort to interview or depose the Adelsons. And it wasn't until 11 days before the discovery deadline, and with just weeks to go before trial, the state announced its intention to interview the Adelsons. And after the deadline passed, this should not be allowed. The state has had years to issue investigative subpoenas and interview the Adelsons, but affirmatively chose not to. State addresses that argument in their response. There are no exceptional circumstances, and therefore they should be precluded. Okay, my takeaway from all that, this sounds really familiar. This is a really familiar argument from this defense. This whole idea of delay, there's nothing here, there's nothing to see here because there were years and years and years and no one was arrested. So therefore, because years and years went along and there's nothing there, right? This delay. This is a common thing. We've seen this thread. We've seen this as a basis of their failed motion for bond in that Arthur hearing in September 22. We've heard a similar kind of, position when we've heard about Rashbaum's comments on Katie's proffer, being a big nothing burger. So, this idea that, so just because it wasn't done right after Dan Markel was murdered, therefore, this should be some type of, justification as to why the state shouldn't be able to interview Donna and Harvey. It's the same thread we saw in their motion to suppress the wiretap evidence, arguing, this is stale information, and therefore there's no justification. I think it's a losing argument. I could be wrong. This is just my opinion, not legal advice, just my opinion. But I just don't see the defense. I don't see the court granting this for this reason. The state responded on Friday, so I'm going to go ahead and pull that up now. Okay, so here we go. So this, as I mentioned, the state responded on Friday, and essentially they're requesting that the court deny Charlie's motion. And specifically, what they argue here is that it would circumvent justice to allow Charlie to call witnesses at trial that he listed on the witness list on the day of the discovery deadline. And one of the things that the defense had argued in their motion, again, this delay, why now? They had plenty of time. They had so many years to conduct these witnesses and they chose not to. Well, here's where the state responds to that. And they say, there were unknown or witnesses that were previously unknown or had previously indicated that they would not be witnesses. So it's not like when the state knew on the discovery deadline what was going to go on, because remember, the Adelson's attorney had consistently told the state, beginning in August when they first spoke with her, that since the receipt of the initial subpoena, that her clients would likely plead the fifth and not cooperate. So from the state's perspective, that's what they're hearing from their lawyers. And then it was also pointed out in the state's applications for the wiretaps that investigators had attempted to interview Donna and Harvey and that they refused to be interviewed. So this idea that the state knew for years and years that Donna and Harvey would talk to them, they just were too lazy to issue a subpoena, is not a credible argument, in my opinion. And the other thing is that the state knows that if the defense calls the Adelsons, Harvey and Donna don't get immunity. But I think the kicker here is that, most importantly, what the state is saying to the court is that, and then to allow Charlie to use a technical discovery deadline as a sword to preclude the state from knowing what the contents of Donna and Harvey's testimony is going to be, that's an unjust result. So they conclude that if they, meaning Harvey and Donna, are going to testify at trial, they should be compelled to answer these questions as required by law or be stricken as witnesses. And I tend to agree. Again, this is not legal advice. We'll have to see how the court rules tomorrow. But I think that the court is not going to grant the defendant's motion And I think they're going to agree with the state that even if there was this technical violation that the actual interviews didn't get completed before September 22nd, the fact that the notice was there before the deadline, and that from a pragmatic perspective, loose ends like this happen all the time during trial. I mean, sometimes things come up during trial. So I just don't see the court allowing this result to occur. And I think, though, what's interesting is this last sentence here. And I'm wondering if this is what we might hear tomorrow. So what the state says here is that if these witnesses are going to testify at trial, they should be compelled to answer questions before trial as required by law and equity, I would argue. Otherwise, they should be stricken as witnesses. So presumably, this motion will be heard tomorrow along with all of the other pretrial motions. But it's interesting. Could this be a situation where the defense just goes ahead and agrees, okay, we'll take Donna and Harvey off of our list? I think that Donna and Harvey would probably want to come off that list. So anyway, let me know what you think. I'm really looking forward to the motions tomorrow. I mean, we've got motions in limine from both the state and the defense. We've got the defense's motion to suppress and some other motions. So I think it's going to be super interesting. I'll report back after tomorrow and give you my thoughts. And in the meantime, thanks so much for joining, and I hope to see you in my next one. Bye.